Hi, I'm Shaye Larkin and thank you for visiting. If you've watched my other videos, you know that I'm a bankruptcy attorney here in San Francisco, and in this video I'm going to talk about why it's important to have an attorney when you file bankruptcy. Now, I know that attorneys can be expensive, but bankruptcy attorneys come in all price ranges, and there are some that are really accommodating to people's financial circumstances. And like I, for example, reduce my fees frequently for people so that they can afford me. I do have a bottom line, but I am flexible. But if you think you cannot afford an attorney and decide to proceed alone, it can end up costing you a lot more, because mistakes can be made in bankruptcy cases that result in lost assets and worse. So I'm going to go over a few of those. If you file the wrong chapter, then you could lose assets because they're not exempt. For example, you have a house with too much equity and you file Chapter 7, well then your house is at risk of being liquidated for the benefit of your creditors. Chapter 13 might have been the better bankruptcy to file. You are behind on the mortgage and you think that the right chapter to file is Chapter 7 to help with those mortgage arrears. It isn't. As soon as that Chapter 7 is over with, the creditor can foreclose, or even sooner than that if they get relief from stay. And if the mortgage creditor gets relief from stay to foreclose on your house in a Chapter 7, then even if you later realize that you need to file Chapter 13 and try to convert, it's too late. They've already got relief from stay. Relief from the automatic stay is what relief from stay means, and that means that they get permission from the court to proceed with the foreclosure sale. So you can really screw up your situation by filing the wrong chapter. You might also leave out assets and debts thinking they don't matter, or forgetting because you didn't have an attorney conducting a probing interview to make sure you didn't leave anything out. If you leave out an asset, then you lose your right to exempt it. You can also be prosecuted if you intentionally leave out an asset. So it's really important to not leave out assets and to not leave out debts. Here in California, if you leave out a debt in a no asset bankruptcy case, there's a case called In re Beasley that protects you. It's if all of your assets are covered by the applicable exemptions, then it's still considered to be part of the discharge even if you left it out. But what if you didn't know to assert the correct exemptions? Exemption schemes are really complicated, and if you are not a bankruptcy attorney, you might not realize that because you haven't lived here for 2 years, you cannot use California exemptions. You need to use instead Utah exemptions, which are not as favorable as California, and maybe you lose assets because of that. If you had hired a bankruptcy attorney, you could have carefully planned your bankruptcy so that maybe you could use the California exemptions, or made other planning moves that would have helped you not lose assets. Maybe filing a Chapter 13 instead. Maybe liquidating the assets that are not exempt and waiting to file bankruptcy until that money has been spent down on necessary monthly expenses. Lots of things you can do to resolve a non-exempt asset situation if you have an attorney helping you. Failing to file the required documents. There are at least 22 different documents that get filed in a typical bankruptcy case, and you have strict deadlines by when they need to be filed. If you don't file all the required documents by the deadline, your case gets dismissed. Now, you know, if your case hasn't been dismissed and the trustee is going after all your assets because you didn't exempt them or you didn't list them in order to exempt them, and by then you start to realize, I need an attorney, well, it's going to cost a lot more money to straighten everything out than it would have had you hired an attorney in the beginning. So These are just a few of the pitfalls that can arise by not hiring an attorney to help you. At the very, very least, even if you know for a fact that your situation is simple, still get a consultation with an attorney just to make sure. And make sure it's a reputable bankruptcy attorney who practices regularly in your area. Alright, so hopefully this helps. Another problem is relying on misinformation on the internet. There's a lot of it out there. So again, I can't emphasize enough, go to a reputable bankruptcy attorney who can set you on the right path and make sure you avoid all of the pitfalls that the people who choose not to retain an attorney experience. Thank you.